Hi, I'm Ken Fossen. Today we have part 3 of our review of the Nebraska Student Discipline Act. More specifically, we're going to review matters related to the formal student discipline hearing and subsequent appeals. Let's start by assuming it's Friday afternoon at 5 o'clock and you're walking out of your office when a parent walks up to you and hands you a request for hearing. If at that moment you think you hear a clock ticking, that's good news. Your instincts are serving you well. Let's see if we can find the source of that ticking sound by first reviewing section 79-269, which states, if a hearing is requested within 5 school days after receipt of the notice that was sent by the superintendent to the student and parent, the superintendent shall appoint a hearing examiner who shall, within 2 school days after being appointed, give written notice of the time and place for the hearing. The hearing shall be scheduled within 5 school days after it is requested, but such time may be changed by the hearing examiner for good cause. No hearing shall be held upon less than 2 school days' actual notice, except with the consent of all parties. The student and the student's parent, guardian, or representative have the right to examine the records and written statements referred to in the Student Discipline Act, as well as the statement of any witness at a reasonable time prior to the hearing. Okay, let's take a moment and put together these sections to see what time constraints we're working under. If the parent submitted the request to us on Friday, February 1st, then we need to have the hearing within 5 school days. So that would be the following Friday, February 8th. Since the hearing examiner is required to give notice at least 2 days prior to the hearing, he or she will need to do that no later than Wednesday, February 6th. Since there may be multiple people who will be involved in the hearing, it may take a while to find a time that works for everyone, so the superintendent should engage a hearing examiner as soon as possible, like right away on Monday. This leaves the rest of Monday and all day Tuesday available for working out an agreeable time and place for the hearing. Keep in mind, if there is not a date and time that works for all of the participants, the administration does not have the authority to extend the hearing date into the following week. Only the hearing examiner has that authority, so he or she needs to be on board early. Additionally, the hearing examiner does not have the authority to just arbitrarily decide to extend the hearing deadline. He or she must do so only upon a showing of good cause. That good cause will come from listening to the reasons given by the party desiring the extension. Finally, the student and his or her parents and representative have the right, prior to the hearing, to examine the written statements and the witness statements the administration plans to present. So that can be done on Thursday, February 7th. That's a pretty aggressive timeline, but we need to remember that the student is likely already suspended pending the outcome of the hearing. And arguably, due process delayed is due process denied. So it's understandable that the legislature would require schools to act expeditiously in providing the hearing. Okay, so what's the hearing like? Let's start with section 79-77, which provides, in conducting the hearing examiner shall not be bound by the rules of evidence or any other courtroom procedure. That section might give you a somewhat inaccurate impression because there are other provisions that make the proceedings look a lot like a traditional court proceeding. Section 79-280 provides that the proceedings shall be recorded at the expense of the school district, similar to the recording requirements for court proceedings. Section 79-273 provides that witnesses shall be present only when they are giving information in the hearing, similar to the court ordering sequestration of witnesses. Section 79-278 provides that both parties and the hearing examiner may ask witnesses to testify at the hearing. Such testimony shall be under oath, and the hearing examiner shall be authorized to administer the oath. And both parties and the hearing examiner have the right to question any witness giving information at the hearing. All of this is similar to court proceedings where both parties have the right to call their own witnesses and the right to cross-examine the other party's witnesses. And just like court proceedings, all of the witnesses at the hearing will be required to testify under oath. Section 79-276 provides as follows: at a hearing, The principal shall present statements in affidavit form of any person having information about the student's conduct and the student's record, but not unless such statements and records have been made available prior to the hearing. In case there is a viewer who is not familiar with an affidavit, here is a sample. In short, it's a written statement being made under oath. It will have the location where the written statement was executed, the name of the affiant, that's the person who made the statement, an acknowledgement that the statement was made under oath, the signature of the affiant, and the name and seal of the notary public who was present during the execution of the document. Statements made in an affidavit should not be taken lightly. Section 28(9)15 provides that a person is guilty of perjury if he or she makes a false statement under oath when the statement is material and he or she does not believe it to be true. Perjury is a Class 3 felony. The hearing will continue in a manner similar to court proceedings. At the end, the hearing examiner will likely ask both parties to make closing statements, again, similar to a court proceeding. Section 79(282) provides that after a hearing, a report shall be made by the hearing examiner of his or her findings and recommendation of the action to be taken, which report shall explain in terms of the needs of both the student and the school the reason for the particular action recommended. Such recommendation may range from no action through the entire field of counseling to long-term suspension, expulsion, mandatory reassignment, or an alternative educational placement. A review shall be made of the hearing examiner's report by the superintendent, who may change, revoke, or impose the sanction recommended by the hearing examiner, but shall not impose a sanction more severe than that recommended by the hearing examiner. Then Section 79(283) provides that written notice of the findings and recommendations of the hearing examiner and the determination of the superintendent shall be made by certified or registered mail or by personal delivery to the student or the student's parent or guardian. Upon receipt of such written notice by the student, parent, or guardian, the determination of the superintendent shall take immediate effect. The student then has the right to appeal the superintendent's determination to the board. Section 79(285) and 79(286) provide as follows. The student may, within 7 school days following the receipt of the written notice of the determination of the superintendent, appeal the superintendent's determination to the school board. A hearing shall be held before the school board within a period of 10 school days after it is requested. The hearing may be held before a committee of the school board of not less than 3 members. After examining the record and taking new evidence, if any, the school board may withdraw to deliberate privately. The board may alter the superintendent's disposition of the case if it finds the decision to be too severe, but may not impose a more severe sanction. And finally, the student has the right to appeal the board's decision to the district court under Section 79(288), which provides that any person aggrieved by a final decision shall be entitled to judicial review by filing a petition in the district court within 30 days. That concludes Part 3 of our review of the Student Discipline Act. In Part 4, we'll conclude our review by sharing a few additional statutory provisions and some thoughts and suggestions for your consideration. Thanks again to the attorneys at the Perry Law Firm for their assistance in planning, researching, and writing for this presentation. And as always, thanks to you for watching. See you next week.